senior member of the bar, who will also be there, and the Electoral Commission, of course, being represented there by their legal team. Now, we cannot delve into the niceties or the technicalities of the hearing because we do not want to subject ourselves to we don't want to subject ourselves to discussing the merits and the demerits of the petitions now before the court gets into the issues they are in. But it's just going to be another very lovely moment, of course, to set our jurisprudence, of course, very clear. This in history is going to be the fourth presidential, or is the fourth presidential elections petition from when we took the path of solving electoral disputes in the courts of laws. Remember, we had one in 2001 of Kizza Besigye versus Yoweri Kaguta Museveni. We had another in the subsequent election of 2006, again of Dr. Kizza Besigye versus Yoweri Kaguta Museveni. And we did not have one in 2011, but we had one in 2016 of Amama Mbabazi versus President Yoweri Kaguta Museveni. And now this comes on as the fourth. Now, it's just very good that it keeps informing us, and of course, coming up with quite a number of recommendations that also help us to shape and to prepare and to make right our electoral laws, and it also prepare for such disputes. Now, it's very clear in our constitution, we know very well, our constitution is very clear on electing a president. Now, when the president is elected or voted for, and there are parties that feel that the process was not the best, it was not free and fair, and they feel the election had hitches, issues here and there, and then the only way to settle these disputes is by going or running to court. Now, that's what the Constitution talks about in Article 104 of our Constitution of 1995 as amended. Now, it's another way to go, and it's another path to actually follow to get there. So that's why the Honorable Kyagulanyi decided to actually now go to court. As you can see, very shortly we will see the 9-member bench of the justices of the Supreme Court, led by Justice Alfonso Owinyi Dolo, and of course all the others take on or listen to this particular case. Now, the whole world is watching, the whole country is watching to see what transpires and what comes out of this. But we, as analysts, of course, this other side, are also now doing the team statistics, just like we do it in football. In a game of football, we normally do those comparisons of Barcelona team and Chelsea team, looking at the pedigree of the players, looking at the pedigree of these, look at the experiences, the cups that they've played, the games that they've played. In this particular case here, we'll look at the number of cases that these lawyers have actually been in, or faced with, or done, or whatever that means. So we also tend to look at those and see, getting into the biographies or the personalities, and of course, the personal profiles of these lawyers representing the different parties, to actually see and how to see how they play out and manage many of the things. At the end of the day, for better for worse, it still elevates them, because for a lawyer who actually now gets at that level, face justices of the Supreme Court, argue out your case, even when you lose, it also puts something onto you to actually say, yes, this is what I did. Now, remember that many of the things that we will see play out here, agreeing on quite a number of things here, especially on matters of law, on issues of law, then of course the technicalities that may come in there. But we are now just waiting to hear from the different submissions that will come on, and we just encourage people that this is the best way to go. Now, you'll notice that at the end of the day, the lawyers from the different divides will not or may not agree on certain issues, but of course that does not stop them from being comrades or lawyers or members of the same fraternity, because that is what they were trained to do, that is what they studied to do, and that is what they actually do. So the rest of us, of course, will be watching, will be following very closely to actually see and know how it plays out and how it keeps transpiring, and of course to get to the niceties in this particular presidential elections petition. Like I said, it is the fourth in our history, and it's not a unique situation in Uganda. It's happened before, and this is what many countries, or this is what most democracies actually do. Even in the United States of America, where we also saw one happen here in the Bush-Al Gore encounter. We saw that happen, and one of their constitutional lawyers there, Alan Morton Dazowich, actually wrote a book up after that and said he called it the Supreme Injustice, saying it was the first time in so many years that he saw the Supreme Court in the United States delivering a president to the people of America, even when they had chosen their own president. So this is actually what happens. And now in this particular pre-conferencing here, like we said, it's a time when the different parties come, the different attorneys come to agree on a number of things, how they are actually going to run through the process, what they need to consider, what needs to be done to do, to just get to set the ball rolling for how it will actually play out. So that is what happens today. So for you who possibly does not know what happens in this particular court here, it's the pre-hearing sets the ball rolling for now the main hearing of the suit that Honorable Kyagulanyi brought to court. So this is actually what we're going to look at. What we saw on Tuesday was they had come to ask for some amendments, which of course were thrown out on matters of law. They were not thrown out on legal technicalities. Now the cases that of course we've seen courts throw out when they've thrown them out on legal technicalities are not necessary on matters of law, because this is how the law operates, or this is how the law works. But as you can see, of course, our able team at the Supreme Court this morning will make sure that they give us that nice coverage of what is happening. Bernard Diga, Sam Senon, and the others who are actually there to ensure that we actually belong to court, as you can see. Now, the Attorney General, another very seasoned lawyer here, of course, William Biaruhanga, leads the team there, and of course at the bar, as you can see. But of course, General Kaguta Museveni, Tibuhabura of the National Resistance Movement, also has assembled his team of very able lawyers who you can actually look at with a pedigree, that these are people who actually do this thing for a living, and they do it every day. So everything they think, everything they talk about, everything they resonate with is actually because it's a calling, it's a career, it's a profession, it's what they keep doing every other day. And of course the other side of the petitioner, Honorable Kyagulanyi Ssentamu, of course, he also has another very young team there of lawyers, Wameri, Segona, Abdallah Chiwanuka, Elias Lukwago, and quite a number of those. So it's really going to be tough for both ends, because matters of law are not things that you think you can just ride over and think it becomes very obvious, because it depends on how much you can argue out your issues, how much you actually bring it up, throw it back and forth to see what happens. But it's a contest of brains. When you get there, it's not really who abuses the other very much. It's not who will actually fight. It's not muscle power, but it's actually brain power. And it's not just brain power, but you also need to know how to argue out the law to make your cause, to make your case, or to argue out your cause and see what happens. But of course, the cause of action here is very important, because what the courts really going to establish here, whether there was a right, whether that right was infringed upon, whether there is actually any remedy, and whether the persons actually that infringed on your right are the persons that you've also brought to court. Now, these are the issues that the law looks at when you go to settle a dispute like that in the courts of law. It's very important to actually know that there was a right, and this particular right was actually infringed upon, and that the persons that you've brought to court are the same persons that you do believe actually infringed on your right. And of course, it also get to the remedies, if there are any remedies, and you know that the only person or the only place where you can actually get these remedies or the damages is court. That's why people choose to say, I'll not go any other way, but I'll choose to go to court. Now, that's very important. And for a country like Uganda, or for any growing democracy, or for any civil country, it just means that the best way to go is, of course, going to court. Because if you do not go to court, then you choose the violent way of sorting disputes. That's why it's encouraged that, yes, when you feel you are disenfranchised, you disgruntled, you didn't get the best out of a process that you participated in, then you choose to say, we'll go to court, and the courts will actually arbitrate. The courts will actually tell us the next way forward, the next thing to do. So this is a case that, like I said, will not get into the sub judice rule of discussing the merits of negotiating what the other party brought, what this party did. We, of course, saw the petition of Honorable Chagulanyi, and some of us have also had an opportunity to read the responses and of course, the different grounds that the respondents are also bringing in. But remember, at the end of the day, just like when we talk about elections, we're telling you, yes, we look at the elections, people are casting their votes here and there, we're getting information, we're getting news of who has won here, who has won there, but what we're telling you is just provisional results, waiting for the Electoral Commission to then tell us who has actually won the election, and they declare them winners, because that is the law. We kept telling you that. So even here, some of us can have our sentiments about what is going to happen in court. We can have our sentiments. We can try to edge out the legalities and the illegalities in the processes, and anything. We can just try to speak our minds on quite a number of things, and possibly say we think it should be this, we think it should be that, or we thought it should have been this way. But these are our own personal opinions or sentiments that should not inform the justices or the judges in there to say they are taking a decision because of maybe what the public said. But of course, we also know that in such cases and in such issues, even the justices there, as they are reasoning the law, as they are reasoning out on these issues, the matters of law and the technicalities in here, they also have the consciousness of, the political consciousness, the human consciousness, all the things. But of course, what rides over the others, because it just shouldn't be about the emotion, it shouldn't be about affiliation, it shouldn't be about religion, it's not about all the things. So that's why we are saying we're leaving it to the lawyers in there to actually put up their case, to argue their case. And at the end of the day, of course, the judges will take a decision, and they will give recommendations after giving a ruling over what they think has come out of that particular court. So it's one battlefield that the rest of us will stay here enjoying to actually watch, because I'm telling you, it's just very exceptional to listen to legal arguments back and forth, and of course, every one of them trying to prove a point, and every one of them are trying to throw out another point or another argument, and we think that's the way to go. So even back to us in our discussion spaces, in our conversation spaces, especially on social media, if you could just learn to live with our diversities and appreciate that, yes, I may be black, I may be brown, I may be this tall, I may be short, I may be all these things, but yes, there are certain things that we can agree upon, and there are certain things that we can just agree that we will disagree on these particular ones. And once we disagree on some of these issues, then it doesn't make you more Ugandan, and doesn't make me less Ugandan. Professor Patrick Lochutieno Lumumba of the PLO Foundation in Kenya, my very good friend, and one of the people that I love following, who of course was in that election petition in Nairobi of Uhuru Kenyatta, being taken on by Raila Odinga, has a very good word that he normally says, that we looking the way we look like, we are not lesser beings of a lesser God. So even in this particular case, so when you go to court and win, then you don't make those that you've won over lesser beings, or you do not make them children of a lesser God. So once we get to appreciate that, yes, I am not less Ugandan because this is how I look like, and I'm not more Ugandan or a greater Ugandan because of maybe the particular achievement that I've got. So I just want to let you, just of course want to usher you into the Supreme Court today, why it's going to happen. You've seen the prims here, and you know the arrangements. of course, the lawyers here representing the different divides seated. They are ready. Now, this is actually what is most interesting about that, because the lawyers of Honorable Kyagulanyi are not fighting with the lawyers of Yoweri Kaguta Museveni. They are not fighting with the Attorney General. Now, they are seated and even sharing notes. You know, they are asking from each other, share with me the compendium of the electoral laws that you have, for example, and somebody has it, and that's where we are. So, welcome to the Supreme Court this morning. My name is Jagana Semakola Ziksoka, wishing you a very good view of the pre-hearing conference. As you can see now, the justices taking position and taking their seats. Welcome to the Supreme Court in Kololo today as we participate in the pre-hearing conference of the Presidential Elections Petition 2021. Good morning.
Presidential Petition number 1 of 2021. Kyagulanyi Sentamu Robert, the petitioner, versus Yoweri Museveni Tibuhaburwa Kaguta, the Electoral Commission, the Attorney General for the respondents, before the Honorable Mr. Justice Alphonse Kyagumoyi Owiny-Dollo, the Chief Justice, Honorable Lady Justice Dr. Esther Chitimbo Kisache, Honorable Lady Justice Stella Aracha Amoko, Honorable Mr. Justice Ruby Opio Aweri, Honorable Lady Justice Faith S. Monda, Honorable Justice Mr. Paul Kaibale Mugamba, Honorable Mr. Justice Ezekiel Muhanguzi, Honorable Lady Justice Pasenai Tuhaise, and Honorable Mr. Justice Mike Chibita.
Yes, Learned Attorney General, can I be heard?
Yes, my lord.
Are the people behind hearing me? Looks like not. Counsel, can you get me? No, this is better, yes. Yes, Attorney General, you can.
Thank you, my lord. If it may please you, my lord, the Honorable the Chief Justice of the Republic of Uganda, my lords, the justices of the Supreme Court of Uganda, my lords, my names are William Biaruhanga, the Attorney General of the Republic of Uganda, and if I may introduce the lawyers assisting me, my lords. I'm appearing with Mr. Francis Atoke, the Solicitor General, Miss Christine Kahwa, the Acting Director Civil Litigation, Mr. Martin Mwangusha, the Commissioner at the Ministry, Mr. George Kalemera, also a Commissioner at the Ministry, my lords, Mr. Richard Adrole, Principal State Attorney, Mr. Geoffrey Madete, Senior State Attorney, and Mr. Brian Musota, a State Attorney at the Ministry. My lords, for the first respondents, they are represented by Mr. Ebert Biencha, Mr. Kiwanuka Chiriowa, Mr. Edwin Karujire, and Mr. Usama Sevufu. Usama Sevufu. Usama Sevufu. My lords, for the second respondent, they are represented by Mr. Joseph Matsiko, by Mr. Ellison Karuhanga, Mr. Alfred Oriem Okello, Mr. Eric Sabiti, and Mr. John Jet Tumwebaze. My lords, for the parties present here, we have Mr. Stephen Tashovia, who is a commissioner with the Electoral Commission.
We don't see him.
And my lords, we have Ms. Kasule Lumumba, the Secretary General of the NRM, for the first respondent. My lords, appearing for the petitioner, we have Honorable Medad Lubega Segona, Honorable Asumani Basalirwa. My lords, we also have Suleiman Kakeire. We have Abu Bakar Sekanjako. We have Shamim Malende. We have Frederick Kalure. And we also have Muwada Nkunyingi. Sorry.
With the permission of the Attorney General, it's Muwada Nkunyingi.
Thank you. Muwada Nkunyingi, my lords. My lords, if it may please you, following the directions of this honorable court, the last time we were here before you, the court gave the directions, and we did request our colleagues, the learned friends for the petitioner.
Before you do that,
Yes,
learned Attorney General, Council Lubega, I see a stranger in the council's gallery. Can you explain? For the gallery meant for council for the petitioner.
Thank you. With apologies, my lord. Mr. Arias Lukwago is part of the team duly instructed. Unfortunately, he did not rob.
Then we cannot see him. And he knows the rules.
Thank you, my lord. And
Yes,
we shall take remedial
he doesn't
action.
belong where he is.
My lord, we shall take remedial action immediately.
That has got to be immediate. Yes, learned Attorney General can proceed.
My lord, as I was saying, following the directions of this honorable court, the last time we were here before you, we did go ahead and request our learned colleagues, counsel for the petitioner, in writing to meet and agree on the issues for consideration yesterday. However, we were informed, equally in writing, that they were unavailable as they were engaged in filing affidavits, and therefore that they could not make it for our pre-hearing meeting. My lords, on that basis, we came up with some proposed issues which we served on the court as well as on our colleagues, the learned counsel for the petitioner. My lords, this morning we had occasion to discuss with our colleagues, learned counsel for the petitioner.
Learned Attorney General, there are no colleagues in legal practice. Those are your learned friends.
Most obliged, my lord.
Colleagues is in politics. These are your learned friends.
Most obliged, sir.
Thank you.
So we had occasion to discuss with learned counsel for the petitioner, and by and large, we have agreed on most of the issues. Having said that, my lord, we would request your guidance on a couple of items that we didn't find total mutual agreement on.
Thank you, learned Attorney General. I thought we would begin with what facts have you agreed on? Where do you have divergence, which would then determine the issues for determination by this court? I see here you have stated agreed facts, agreed within the counsel for the respondents, because counsel for the petitioners have not appended their hand, so we take it that this is your proposal. Yes. So in your discussion, you laid down agreed facts 1, 2. I don't know whether they have 3. Yeah, 2 of them. So wanted to know, do they agree? Are you adding something? If not, then we go to the next one. What issues arise?
May I be permitted, my lord?
Yes, learned counsel.
My lord, thank you very much. First, we start with an apology, yes, for our inability to have attended the meeting.
Yes.
We made efforts to communicate with our senior, the Attorney General. We actually did not say we were engaged in filing, but preparing affidavits. We suffered a setback when some of our witnesses continued to go missing until yesterday, early in the morning, when we received telephone calls from Barara where they had been dumped. That took a large part of the day trying to get them, and later in the afternoon, as we attempted to access them, having sent somebody to pick them from Barara where they were dumped without transport and were using strangers' telephones, we were informed that some of them were engaged in a meeting with the Deputy Inspector General of Police, who had picked interest in the same. As a result, my lord, we were not able to meet, and that is the message we are communicating with a copy to the registry. We deeply regret this. My lord, that having been said, in our discussion with counsel for the respondents this morning, we did indicate that whereas we agree with substantially the proposal which was served on to us this morning, we wish to add some more proposals in writing. We did propose to them that with your guidance and permission, it would be neater to go through the document and give our comments, and we file a joint one, as you may guide. After that, my lords, we also did indicate to council that we would be filing about 50 affidavits within the course of today, and all conditions allowing, we would be filing another 50, if you permit, by Monday. And those are substantially the gist of the case. Others may come in with your permission and leave as we progress with the matter. We also proposed that in a bid to save time, after filing, we would generate our skeleton legal arguments for purposes of submission, so as to give advance notice of what we intend to do in the course of next week. Our prayer, my lords, again with apology, is to have the pre-hearing session adjourned to another convenient date, as you may be pleased, where we undertake to be more organized, prepared, and definitive in how we move. I believe by that time we would have sorted out most of the issues that are to do with the scheduling of the matter, including documents, some of which may not be discussed now without them attached to affidavits which are yet to be filed. We therefore, my Lord, humbly pray that you be pleased to grant us more time to come up with those documents, serve them on to the opposite counsel. Perhaps at the next hearing, we would have, or both parties would have, a full and clearer position of each other. My Lord, also to give notice to counsel, but we shall be more precise subsequently, of our intention to file an application for discovery of some documents and materials which we believe are critical to the determination of this case. We have already requested for some of the documents from the Electoral Commission, and we have not been graced with a response. We hope in the course of 1 or 2 days we would have agreed with the Electoral Commission whether to give them to us as requested or to make a formal application to court, because these are documents we believe are critical and we may not be in a position to proceed effectively and effectually without them. I pray, my Lords, and with the indulgence of my colleagues across, that we be granted that time. Thank you, my Lord.
Yes, Lord Attorney General, what is your response?
Thank you, my Lord. Of course, my Lord, the risk of intermittent filing of evidence is that then, of course, it requires counsel for the respondents to evaluate, re-evaluate, and depending on from what locus, requires to have rebuttals, and all this takes time. Whereas, of course, it is imperative for us to prepare adequately for the respondent's case. The time frames, I will not tire to say, are set. Time is of the essence. And again, at the risk of repetition, Article 104(3) of the Constitution makes it mandatory, as does Section 59(3) of the Presidential Elections Act, about the time frames. Now, my Lords, as counsel for the petitioner has just said, we did have a discussion with them this morning, and they did point out the areas that they had some issues with. It is our opinion that those areas can be discussed and finalized now, this very morning, seeing that this was the day set for the pre-hearing, and that upon disposal of that, then that this court may be pleased to guide us on the further timetable, my Lords.
Well, thank you so much, learned counsel, for the parties. As you are all aware, a presidential election petition is one which, by the Constitution, the Presidential Elections Act, and the rules, must be determined expeditiously and within specific time frame. The court has no power to expand, there's no latitude to expand this time frame. Beginning Tuesday the 2nd of this month, last Tuesday last week, we must determine this matter within 4 to 5 days. It is really, really important that we abide by this timeline, because we may end up with a crisis. We have to apportion time for each stage, for each action in the process. We have to give it reasonable time. The law gives what it considers reasonable time, 15 days, within which to file a petition when one is aggrieved. The law gives very limited time frame for response by the respondent, 3 days, whereas in the ordinary civil matters, one is given 15 days. For a presidential election petition, it is 3 days for the response. It's 10 days today since time began running. We've used 10 days out of the 45 days. Learned Counsel Obega, the petitioner was expected to have filed affidavits, either together with the petition or soon thereafter. You've utilized 10 days. I have not seen one, unless you filed one this morning. But we count the period. You ought to have filed affidavits as your time. Accordingly then, this is the timeline court is giving to the parties. Quite strict. If we are to fulfill the legal requirement prescribed in the Constitution, the Presidential Elections Act, and the rules made thereunder. We give the petitioner an additional period of up to Sunday the 14th, that is this coming Sunday, to file all affidavits. So beginning today, up to Sunday 14th, the petition is expected to have filed all affidavits. That gives you the benefit of about 14, 15 days from the date you filed the petition. The respondents, and I'm going to guide you on how service will be done. The respondents on whom service would have been done already have up to Saturday the 20th of this month to file their own affidavits. The petitioner will have up to Monday 23rd this month to file any affidavits that may be required in rejoinder. On the 24th, we will continue with the process you are not able to conduct today. The prayer you were making, Learned Counsel Obega. You will then have sufficient time to have discussed, to have had the benefit of the various affidavit evidence from both sides or from all the sides, and present to this court on the 24th of this month the scheduling memorandum, which would indicate what you have agreed on, what are your points of divergence. Then we arrive at the issues for determination by this court. Then on the 24th itself, if there are any applications to make, you have the opportunity to present those applications to court on the 24th. But I need to point out, and I particularly appeal to counsel for the respondents. There is absolutely no reason why the petitioner must apply to court for discoveries. If there are any documents in the possession of your clients which the petitioner wants to use, they should be availed easily. There's absolutely no reason why counsel must have to apply to court and court has to give an order. In the interest of the due process, I expect Counsel Lubega and your team liaise with the Attorney General, who is the lead counsel on the other side, so that if you need any document from any of the three parties, it should be availed. Then if there are difficulties, then the matter can come before us. So when we are done with the pre-hearing scheduling, the trial, on the 24th, then we will proceed to written submissions. Written submissions is going to be a major component of the hearing. The petitioner will have up to Saturday the 27th of February to file their written submissions. The respondents, all of them, will have up to the 2nd of March this year to respond, and the petitioner will have up to March the 4th for any rejoinder that may be necessary. Then on Friday the 5th of March, the court will accord mandate counsel for the parties the opportunity to make oral submissions strictly for purposes of highlighting. Strictly for purposes of highlighting, not again to come and cover the entire submission. The learned lordships are able to read and internalize whatever you will put down. So, counsel on both sides, you are a responsible person, you're led by senior learned counsel on both sides. You know what material court needs to make your case. You know what material court needs to defeat the case put by the other side. Please do not meander all over the world. Do not bring us volumes from the floor to the ceiling. We really need to know what you have in your arsenal to make your case. I believe counsel understand what I'm saying. And on that 5th of March, your submissions in highlighting will be for 30 minutes, strictly 30 minutes. When your 30 minutes clocks, the Chief Justice will have the unpleasant duty to ask you to sit down. And then rejoinder will be for 20 minutes, and that will conclude the hearing. No, no, I haven't concluded. Then we can. Before that, on the 25th to the 26th, court would avail you the opportunity to cross-examine witnesses that you would have notified court, and counsel for the other side you intend to cross-examine. Court would avail you the opportunity to present whatever electronic evidence which you would have applied for, if any. Then subsequently we go to the highlighting of the oral submissions I've already talked about.
I beg your pardon, my lord, on the date for the visual electronic evidence.
Yes.
On the date, my lord.
Come again?
Yeah. I beg your pardon on the date when that electronic evidence may be presented.
25th to 26th.
Also like, my lord.
Yes, of February. The 2 days for cross-examinations and for receipt of any electronic evidence that may arise. And as I said, 5th, we'll have the oral highlight of written submissions already in court's possession. The court will then retire and use the duration of 7th to 18th, which I think is 10 days, to write its summary judgment to be delivered on the 18th of March, so that we are within the 45-day period. As you can understand, if you disturb this schedule, we'll run into problems. We've given you sufficient times. We do not intend that the little time we have given court to avail you the opportunity to present your case should be eaten up more. So everybody will do everything that needs to be done to ensure that we keep within this time frame if we are to render justice in the matter before us. The other direction is court is going to set up desk for representatives of counsel for all the parties. The moment an affidavit is filed or any document is filed, the court will serve on your representative in court. That will ease the problem of my learned counsel is saying yes, 50 affidavits and another 50. That's okay. But then the three respondents will have a desk each, just like the petitioner will also have a desk each provided by court here. The moment the document is filed, it is immediately served on the opposite side. This is really done for purposes of expediting, for purposes of ensuring that we don't run into problems, say, oh, we were not served, we were not open, and so on and so forth. In this regard, the Saturdays and Sundays, beginning next week and subsequently, up to the time when there is need to file documents, the registry of the Supreme Court will be open. It will be a working day for the court from 9 to 5 o'clock. And we hope, and it is in your interest, that on each of those days and subsequently, when documents are supposed to be served, please maintain the presence of a representative who must have a stamp of the law firm representing, or one of the law firms representing the petitioner on each of the respondents, so that when the document is served on you, you're able to stamp on the court copy and sign that you've received. I believe I'm clear on this. Is there any question? No? Are you seeking any clarification? Yes, Councillor Kiwanuka.
Yes, may it please your Lordship and honorable members of the Supreme Court, honorable justices of the Supreme Court. Everything is pretty much clear.
No, you have to tell these machines what your name is. It doesn't recognize you until you...
Most obliged. For the record, my Lord, my name is Chiriwa Chwanuka, counsel for the first respondent. My Lord, pretty much everything is clear, save for one issue on electronic evidence. We understand that the same will have to be filed with affidavits and served on the parties so that we can be able to challenge it either with counter evidence or challenge it legally. Because the dates were given for receiving electronic evidence which was outside the time for service of affidavits. But we just want to clarify that by the time they are presented for viewing, they would have been introduced properly using an affidavit so that we can be able to put in affidavits in response and or challenge them legally.
That's the law, no?
Yes, my Lord.
Yes.
Most obliged.
So you cannot bring an electronic evidence except by affidavit.
Most obliged.
By the time we reach that date, it should be on record.
Most obliged,
Then we determine its reception and admissibility. Yes. Any
My Lord, I can only say it's axiomatic, and we shall follow the rules.
You follow the rules. Thank
Yes.
you. Yes, my Lord.
I just wanted to inform Council Kirewa. That's why we have given you a night schedule for filing affidavits. Like in the previous petitions, where affidavits were. I'm saying that is why we gave a strict timeline for filing all affidavits. Unlike in the previous petitions, where affidavits were filed, sometimes throughout the hearing, then the parties will not know each other's case. And then you have this trial by ambush going on in the petition, and I think that's what we want to discourage. So when you bring your electronic evidence, we must introduce them by way of affidavits, so that on the 24th, we shall now be viewing them. But they will have already been shared with each other. Thank you.
Let me emphasize this. Thank you, my Lord. Let me emphasize. You see, we've lost 10 days. And there is no way we can cover the 10 days. So the strict timeline I have given for filing affidavit evidence, you'll be lucky if you will be allowed to file an affidavit evidence outside of that timeline. So you really got to go and do work. Because there's a great danger. It will lead to serious ramification if we expand the latitude that you can file an affidavit whenever you want. So the timeline I've given for these actions is really strict. It is also strict on the court. The court must, all those volumes, the court must determine within a space of 10 days. So similarly, you must do your work within the timeline court has given. Thank you.
Emphasize.
Yes.
No. Okay. I just want to emphasize that the registry staff have been instructed very strictly to reject any document that is brought outside the timelines we've given you. We don't want to find documents on our files in the morning of the hearing that has been filed outside the timeline given. So if you are late, forget. They will not receive your document. And you'll have only yourself to blame. Okay? Thank you.
Thank you, my Lord CJ. I just wanted also to emphasize that if there is any correspondence, Council Lubega, you mentioned that you had written to the second respondent. I'm not aware if that correspondence has been put on the court record or copied in on the court record. So there's again to expedite or to assist the court in reviewing, who has taken which initiative and where there are any difficulties. Like the Chief Justice has said, if the parties are corresponding to each other, they must copy in to the court so that court can be updated at all time where you are.
My Lord, we undertake to do that going forward.
Okay.
My Lord,
just let me follow up on that. I really appeal to counsel, especially counsel on both sides. This is about justice. This is about determining whether the grievance before this court has got merit or not. It's not about winning. It is only when you seek to win that you can say, I'm going to deny this document, I'm going to be this. It is. And let me also say, it's not about the petitioner. The question before court is about whether and how we can have an election which everybody is satisfied by. So please, the moment counsel pursues a winning attitude, by all means, by all means, then we deviate from the purpose for which we are here. And elections are not about the candidates. It's about you and me. It's about our country. So I expect total cooperation. I expect decorum. I expect that we pursue. We are going to investigate. We are going to inquire into the grievance which has been presented before court. And because of this, yes, Counsel.
My Lord, my name is Joseph Matsiko, for the second respondent.
Yes.
My Lord, with your permission, I would just like to clarify for the record.
Yes. Is the mic on?
And to clear the record, my lords, that counsel for the petitioner has not served on us in any letter requesting for any documents. We have not received any such letter. So I just wanted to clarify that impression. So it's not true that we are served with any letter requesting for any documents, my lords.
Thank you. Whatever the position is, either two, subsequent to this sitting of court today, we expect total cooperation. We expect that learned counsel, whose responsibility is primarily to this court and then secondly to their clients, will do everything in their power to see that justice is done. Learned Attorney General, your head of bar, you know this. It includes availing your opponent in courts authorities which they may not have, which would help their case, but you have it. That's really what it means. If Mr. Kiwanuka has some authority which Counsel Lubega has never heard of, and it improves on Counsel Lubega's case, the professionality of legal practice says you avail it to the other side. And that's how we should proceed. Yes, it's what makes the legal profession beautiful. It is why you're called learned. We're not just educated, but learned. So it comes with responsibility. Then finally, and this to both parties, to all the parties, the four parties, to the media, there are rules about court cases. They are age-old, and they are there for a purpose. The petitioner has chosen to come to court. He has not chosen to go and present his case in a marketplace. Leave the courts to do their work. And this begins from counsel. I have seen in the print media, I have seen on TV, some people appearing, we shall defeat this case. This is the forum where you can defeat the case. This is the forum where you can succeed to overturn the outcome of the presidential elections that was held on the 14th and declared on the 16th. Nowhere else. We will not take kindly to anyone, more so council, or the parties who have chosen to come to court, who have been dragged to court, now thinking that having had their day in court, they must also have another day elsewhere. We are here because you believe in the rule of law, which is a commendable thing. We are here because you believe, left to do their work, this court can do something, leave the courts of law to sit down and render justice, as is their mandate to do. Let us not misuse social media. If we choose to go to social media to inform, let us give factual information on what transpired in court. That is permissible. Not this disparaging and mud throwing and so on and so forth. For those of you who are old enough, you should know the alternative to a court of law. It is until you're put with a situation where you have a military tribunal. We have seen this before, handling purely civic matters like this. Then you'll cry for a court of law. Some of us are old enough, we saw this happening, where kangaroo justice was meted out. We saw it in this country. So my appeal to those who are old enough like me is to remind them to recall, and for those of you who are unfortunately not as old as I am, to know that the court of justice, the court of law, it may not be perfect, but you don't want the alternative to the court of law. So whatever you do, let us strengthen the courts of law to do their work. And this does not apply to the presidential elections petition only. There are other petitions which are coming parliamentary and for local government. Let us act with responsibility. This is our country. I do not own it more than you do. Nor do you own it more than I do. We own it together. We can destroy it together, or we can lift it up together. And posterity will judge us either in commendation or very harshly, depending on how we handle the opportunity that is present before us.
With information, I think, again, to set the record straight, I did not say that any communication with respect to what I said has been shared with counsel for the second respondent. We have been corresponding with the Electoral Commission.
No, that's okay, that's okay. Yes. London Council, for me, my point is, from now, yes, whatever has transpired, you know, we can spend the whole day saying you did, you didn't do, but I am saying from now, I expect, I do not want the Learned Council, whose responsibility is to me primarily. Then because of that, they have a responsibility to the petitioner or to the respondents to look at one another as if they are opponents. They are not. They only believe that their client has a case, the other person says it is their client who has a case. And you have to present that before us. So I expect that the Attorney General will give you maximum cooperation, counsel for the first respondent, the second respondent. They will all give you maximum cooperation. And similarly, they may want some information from you. We expect it is, yes, it's not a one-way traffic. There's need for reciprocation. What you need from them, if they need something from you, I expect total cooperation. And that's how it should be. Thank you. So, unless something comes up by way of application, you've understood the timeline and when we will converge again here. Please follow the timeline given by court. Then we can all do this together and come to a determination for the good of our country. Thank you so much.
Thank you very much, my Lord, the Chief Justice. This is just to say that on behalf of the respondents, we thank you for the guidance that you have given us. The timelines are all crystal clear, and as far as the respondents are concerned, we intend to abide by everything. We thank you very much.
Okay.
My Lord, I think the Attorney General has abdicated on his statutory responsibility to represent the entire bar.
Yes.
But for the petitioner...
I was about to say that. That in his concluding remark, he should have spoken for the bar, yes.
We thought he would not discriminate against us, but we take it with grace, my Lord.
Court takes it that he misspoke.
Oh, sure.
Yes.
I want to assume, and my Lord, for the record, that he was thanking you on behalf of the entire bar. And I think it is fortunate that some of us are not as old as yourself, my Lord, because we have somebody to follow from.
Okay.
Yes, we do not undertake or intend to advise on the alternative to this court. We are guided by the perennial conduct of court that we must always come here as the last person. And it is our responsibility that we shall be here.
Thank you.
We do not intend to see that tribunal you have talked about. We have seen a semblance of it in March, India, but we think we will get over it. Thank you.
I believe we will not see a military tribunal again. This is my belief. But all that I'm saying is, whatever deficiency the court of law may have, it is an institution. You don't want to go back. We have seen the alternative to a court of law. So in whatever we do, because we love our country, we may differ. Even on points of law, we may differ. But it is the duty of counsel, it is the duty of every Ugandan to strengthen the court of justice and ensure that it properly contributes to the stability and economic development of this country. There is no alternative. Thank you. Yes.
How can I have spoken to them? No sooner had I sat down than they showed exactly. Yes, that I represent them. They should have gone a step higher than me. Instead. Yeah, how? He just proved me, just 2 minutes after.
The day the world stopped was the day we found where to go. From now on, we're not going to leave anything on our plates, because we've learned to savor the moments that were always there, and they